And continuing on page 26, Mr. Speaker, House Bill 1052, a bill to amend and reenact a section of the Code of Virginia relating to the method of execution. Report for Committee on Militia, Police, and Public Safety.
The gentleman from Manassas, Mr. Miller.
Thank you, Mr. Speaker. House Bill 1052 is simply a process bill. The Virginia Department of Corrections right now is having difficulties in finding the drugs necessary to fulfill the task of execution by lethal injection. It's a situation where manufacturers either discontinue the drug or they refuse to sell the drugs to Department of Corrections in Virginia or any of the states for that matter. What this bill will do is it will allow the Virginia Department of Corrections to fulfill the court orders of execution if the drugs are not available by electrocution. Mr. Speaker, I move the House be engrossed and passed on to its third reading.
Gentleman Fairfax, Mr. Sorrell.
Speaking to the bill, Mr. Speaker.
Gentleman has the floor.
Thank you, Mr. Speaker. Ladies and gentlemen, this bill heads in the wrong direction. Instead of debating ways to make it easier to use an antiquated 19th century method of executing human beings, we ought to be talking about ways to make our system more humane. Mr. Speaker, the reason that this legislation has arisen is because Virginia is increasingly isolated in the world in how it deals with prisoners and how it punishes people. The reality is there are manufacturers in Europe who have now refused to continue to sell us lethal injection drugs because they're not supposed to be used to kill people. They're supposed to be used to treat people. Now, the other states that have faced this problem have turned to American compounding pharmacies to deal with the shortage of the drugs. And there's been 2 executions since then that have used alternate drugs made in America to do what is necessary under the current law. Virginia, if it wants to continue to execute people, should follow that course of action instead of continuing to enable the electric chair, which is nicknamed Old Sparky. I once saw Old Sparky when I took a tour of Greensville back in 1993. It's a creepy device. I wouldn't encourage anybody to go look at it. It's been sitting there since 1908, since we started using it. What we ought to be debating here is whether to retire Old Sparky, not giving her more clients, which is what this does. Folks, electrocution is antiquated. It was invented, so to speak, in the 1880s in a fight between Thomas Edison and George Westinghouse trying to figure out whose form of current was more lethal. And actually, the early death penalty litigation was in fact funded by Westinghouse and Edison trying to point that each other's electricity was more lethal to the other. Virginia, just so you understand, when this is adopted, this method of doing this was adopted around the same time we discovered these things called movies, or the same time that Prohibition was in vogue and they invented Coca-Cola. And since then, our society has evolved. Technology has evolved. We have developed more humane ways to do this. Aside from it being unnecessary to do this, because the drugs are available through these compounding pharmacies, and aside from it being antiquated, this technology, electrocution, folks, has never actually been tested scientifically or otherwise. You can't exactly take a human being and say, how'd it go? How did it feel? Right? And there's no science behind this. It's all been trial by error. And they watch bodies catch on fire and blood boil out of people and eyeballs pop out. Every once in a while that happens. But nobody's ever, in fact, verified that electrocution is, in fact, painless, kills people without torture, kills people without brutalizing them. But the reality is that it does. And for years, they didn't have a better way to do it, and so they kept doing it. In 1994, this body chose the preference lethal injection, and that's the way most prisoners have been executed since then. And we ought to head in that direction instead of turning backwards. Folks, most states in this country are going the other direction. 85% of the states in the United States that had electrocution have now abolished it. There are only 4 states in America that still do this to prisoners. It's us, Alabama, Florida, and South Carolina. That's it. In fact, the last reason I'll give you that we need to reject this bill is that continuing to keep electrocution on the books, and in fact, forcing prisoners to be electrocuted if we can't find lethal injection when they choose it, in fact, jeopardizes capital punishment in this state. Challenges to this are more and more common, and it's been rejected now by 2 state Supreme Courts. And they're hardly bastions of liberalism. In 2008, the Supreme Court of Nebraska found that electrocution was cruel and unusual. In 2001, the Supreme Court of Georgia found that electrocution was cruel and unusual punishment. And by forcing people to be executed by a means by which they didn't choose, which is what this bill will do if we can't find the drugs, and it doesn't say what standards we have to go and look around for the drugs or what. It just says that the head of prisons can just certify you can't find them. But by forcing people, it puts our system in jeopardy. The Supreme Court said in 2008 that in Bays v. Reeves, that's the U.S. Supreme Court, not the state one, that proffered alternatives to a method of execution must effectively address a substantial risk of serious harm. To qualify, the alternative procedure must be feasible, readily implemented, and in fact, significantly reduce a substantial risk of severe pain. If a state refuses to adopt an alternative in the face of these documented advantages without a legitimate penological justification for adhering to its current method of execution, then a state's refusal to change its method can be viewed as cruel and unusual punishment under the 8th Amendment of the United States Constitution. Last week, over in the Senate, on the other side, the other body, the gentleman from Norfolk who runs a funeral home related to the body that he'd seen bodies that had been executed. He'd seen the eyeballs popping out. He'd seen the burnt flesh. He'd seen the singed hair. And he said anybody that says that electrocution is not torture is dreaming. I just want to remind the body that when someone's given the death penalty, the state is simply charged with extinguishing a life. We're not charged with brutally torturing someone until they finally die. That's where this takes us. This state was a beacon of liberty. We were a beacon of human dignity and reason when this body adopted the Virginia Declaration of Rights in 1776. And this bill takes us in the other direction. I would encourage the body to vote against the bill.
The gentleman from Henrico, Mr. Morrissey.
Thank you, Mr. Speaker. Mr. Speaker, would the gentleman from Manassas rise and yield for a question or questions?
Will the gentleman yield?
I yield.
The gentleman yields.
I would preface my question by telling the gentleman I understand that the Lundbeck Corporation and Danish pharmaceutical company has stopped sending some of these drugs to the United States in deference to the European Union's opposition to capital murder. But am I not correct that since 2011, the Commonwealth of Virginia has used a 3-drug protocol to administer death, including an anesthetic, pentobarbital, a paralytic agent, bromide, and the third drug that stops the heart, potassium chloride. Is that not the current procedure?
I believe that is correct.
Would the gentleman yield for another question?
Gentleman yield?
I yield.
Gentleman yields.
Given that other states like Georgia, Texas, and Ohio, who also don't have or are not receiving the drugs from Europe and have gone to a different protocol where they switched to a 1-drug regimen, when administered, extinguishes life, why couldn't we do that in a more humane fashion instead of defaulting to electrocution?
Mr. Speaker, I'm not so sure the basis of his question is accurate. I don't know myself of any states using a 1-drug formula. What I do know is that now pentobarbital, that he spoke of earlier, is no longer being sold to departments of corrections around the state. I also know that the state of Ohio attempted to use some of the compounding drugs from the American compounding pharmacies to execute a one Dennis McGuire, which also did not go as well as planned. The convict Dennis McGuire laid on the table, gasped and snored for 15 minutes before he passed away. So what I would say to the gentleman, Mr. Speaker, is the Virginia Department of Corrections, this delegate presenting this bill, and the majority of delegates I know would prefer to keep the option of lethal injection as an option for the Commonwealth of Virginia. The problem is the drugs are becoming less and less available, if not available at all, and this would simply allow the Department of Corrections to fulfill court orders.
The gentleman yield for another question, Mr. Speaker.
Will the gentleman yield?
I yield.
Gentleman yields.
I would ask the gentleman, if House Bill 1052 is passed, would it not be true that Virginia would be the only state in the Union with forced electrocution for death row inmates?
I would not know that, Mr. Speaker. I have no idea what the other 49 states' laws are.
Would the gentleman yield for another question, Mr. Speaker?
Gentleman yield.
I yield.
Gentleman yields.
I'm looking at the gentleman's legislation, and it says, and I'm quoting, if the director certifies that the method of execution chosen by the prisoner or set forth in this section is not available, and the operative words are, for any reason, the remaining method of execution, i.e. electrocution, shall be employed. My question is, would any reason also include that the drugs are expired? In other words, the drugs on the shelf in the Department of Correction that would carry out the execution in the death chamber are expired. Would that be for any reason?
Mr. Speaker, if the drugs are expired, the Department of Corrections will not use them for an execution.
Would the gentleman yield for another question, Mr. Speaker?
Will the gentleman yield?
I yield.
Gentleman yields.
Is the gentleman aware that as I stand here and as we stand here today debating the issue, that those drugs that the Department of Corrections has to utilize, that cocktail of drugs, have expired, and if there were to be an execution today, they could not use a drug because it was expired? Is the gentleman aware of that?
It is my understanding that any reserve that the Department of Corrections had expired on November 30th of 2013, and they do not have access to those drugs currently.
Thank you. Would the gentleman yield for another question?
Gentleman yield.
I yield.
Gentleman yields.
I would ask the gentleman respectfully, what was the logic to default to electrocution as opposed to firing squad, hanging, a sharpened guillotine? What was the reason or logic to default to electrocution?
Mr. Speaker, the reason why we would not use the firing squad, hanging, electrocution, or grenades is because it is not on the state code. It is not a method of execution in the Commonwealth of Virginia. The electric chair is, and it was used as early as last year to execute an inmate on death row.
Would the gentleman yield for a final question?
Gentleman yield.
I will yield for a final question, Mr. Speaker.
Gentleman yields.
Could the gentleman answer me this question? What should Earl Washington Jr. or the Commonwealth of Virginia have done given the following? Within 9 days of Earl Washington Jr.'s scheduled execution, he was exonerated. Not exonerated because there was a Fourth Amendment challenge, but because the state came forward and said, we got it wrong, Earl is innocent. What should Earl Washington have done to choose his form of execution? Lethal injection or electrocution, given that he didn't commit the crime? And if he didn't choose, what should the Commonwealth of Virginia have done to carry out that death sentence had he not chosen?
Mr. Speaker, this question obviously does not pertain to this bill. This bill would only pertain to executions that have been fully vetted, that have gone through all of the appeals process. Therefore, the gentleman that Mr. Morrissey is talking about would not have faced this question at all, and I could not reach into that gentleman's mind anyway if he were to face that question.
Mr. Speaker, thank you. Speaking to the bill when it's appropriate.
The gentleman has the floor.
Thank you, Mr. Speaker. Mr. Speaker, ladies and gentlemen, my colleague from Fairfax gave reasons why we should not default to electrocution because of the horrific nature of electrocuting somebody. Let me tell you, let's be clear what this bill does. It is saying that for whatever reason, if the drug's not available, for whatever reason, we default to electrocution, a truly barbaric means of taking someone's life. I appreciate the candor and the patron from Manassas agreeing that as I speak right now, a for any reason exists. We cannot electrocute, we cannot put somebody to death right now with a cocktail, the 3 protocol of drugs, because those drugs are expired. Accordingly, if this law was in existence right now and we were to execute somebody, carry out a circuit court order to execute somebody today, we would have to electrocute the person. That doesn't make much sense to me. With respect to this Danish pharmaceutical company that's not providing the drugs, they have their own reasons, and we don't know why they wouldn't do that. But my colleague from Manassas is saying default to electrocution. We put our dogs to sleep, to death, better in a more humane fashion than what we're now going to do to another human being. We can put people to death with a protocol of an anesthetic, a paralytic drug, and stopping the heart, just like we do to our dogs or cats. That's painless. But this law says, no, we're not going to choose that option. We are going to default to electrocution where somebody fries. Again, my colleague candidly had talked about an individual in Ohio who took many, many minutes to expire given this protocol of drugs. Imagine the horrors that those people deal with who are electrocuted. The default to electrocution, I submit, ladies and gentlemen, is wrong. It is horrific. It is barbaric, and we ought not to be a party of that. And I'd ask that you reject this bill and not enroll it for third reading. Thank you.
The gentleman from Manassas, Mr. Miller.
Mr. Speaker, speaking to the bill.
The gentleman has the floor.
Mr. Speaker, I appreciate the comments as well as the feelings on the other side of the aisle, and quite frankly, quite a few members on this side of the aisle on this issue. The death penalty is never an easy issue, Mr. Speaker. And quite frankly, I think some of the debates from the other side were about the death penalty in and of itself. What this bill is about process. It's about fulfilling a court order that is simply reserved for the absolute worst of the worst in our society. This is not an easy type of vote or an easy debate for anyone. But I would just ask my colleagues to not listen to, quips and hype, comments such as an antiquated 19th century way of execution. I would say to the gentleman that poisoning someone far outdates electrocuting someone. He said that the American compounding pharmacies still sell these type of products. I would tell that the Departments of Corrections can still get these type of products from American compounding pharmacies. That is simply untrue as well. The American compounding pharmacies are now rarely, if at all, dealing with selling drugs to Department of Corrections around the nation. Using emotional terms like the electric chair, old Sparky, is creepy. Mr. Speaker, again, it's not an easy issue for anybody. But a bed with medical supplies to put someone to death is creepy also. And Mr. Speaker, I would say one last thing, especially from the gentleman from Fairfax, who, again, is opposed to the death penalty in any circumstances, as is the gentleman from Henrico, that I would say that they say that this jeopardizes capital punishment in our court systems. Mr. Speaker, it may well jeopardize capital punishment in our court systems. I'm not an attorney. I don't make appeals before the state Supreme Court or the U.S. Supreme Court. And the gentleman from Fairfax, the gentleman from Richmond, they may make that argument one day in front of the Virginia Supreme Court, and they may win. Mr. Speaker, it might be this piece of legislation that allows them to take that argument to the Supreme Court and win. But what I would say, Mr. Speaker, is, again, this is about the process. It's about allowing a court order after all appeals have been exhausted to be fulfilled. It is not about the merits of whether the death penalty is wrong or right. I move that the body engross the bill and pass it on to its third reading.
Shall the bill be engrossed and passed to its third reading? As many as favor that motion will say aye. Aye. Those opposed, no. No. Bill is engrossed and passed to its third reading.